Landlord-tenant law governs the relationship between parties to a lease. Understanding this relationship begins with recognizing the fundamental nature of the lease itself. A lease is not merely a contract. It is a conveyance. It transfers a present, possessory interest in real property from the landlord to the tenant for a defined period. This transfer creates what is known as a leasehold estate. This dual nature, part contract, part property conveyance, establishes two distinct relationships between the landlord and the tenant. First, there is privity of contract, arising from the promises made in the lease agreement itself. Second, there is privity of estate, which arises from the mutual interest in the land. Visually, think of this as a balance. On one side are the contract rights and obligations, and on the other are the possessory rights granted to the tenant. To structure our study, we must first categorize the types of possessory interests a tenant can hold. We will examine the four primary leasehold estates: tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance. We begin our examination of the four leasehold estates with the tenancy for years. Despite the name, this tenancy does not require the term to be measured in years. It can be for any fixed, ascertainable period: a month, 6 months, or even 99 years. The defining characteristic is certainty. The tenancy has a definite beginning date and a definite ending date, both established and agreed upon in advance within the lease instrument. Crucially, because the end date is fixed by the original agreement, termination requires absolutely no notice from either the landlord or the tenant. When the clock runs out on the agreed-upon final day, the estate automatically terminates. This offers a high degree of predictability regarding the duration of possession, setting it apart from periodic tenancies where notice is mandatory to end the cycle. Moving beyond the fixed term of the tenancy for years, we now analyze the periodic tenancy. This estate is characterized by its recurring cycle, continuing indefinitely until one party takes affirmative steps to terminate it. A periodic tenancy arises either expressly, perhaps stating a month-to-month agreement, or by implication when a tenant pays rent on a recurring basis, such as paying rent monthly without a specified end date. This implication is common when a tenant holds over after a tenancy for years expires, and the landlord accepts the next rent payment. The crucial difference lies in termination. Unlike the tenancy for years, a periodic tenancy requires proper notice. The common law rule dictates that notice must be given equal to the length of the period itself. For a month-to-month tenancy, this means 30 days notice. However, modern statutes frequently impose a cap on this requirement, often limiting the maximum notice needed, even for longer periods, to 6 months. This cyclical nature requires careful attention to the termination notice period. Having covered the cyclical nature of the periodic tenancy, we now turn our attention to the two remaining, less common leasehold estates, the tenancy at will and the tenancy at sufferance. First, consider the tenancy at will. This estate exists where there is no fixed period or recurring cycle, continuing only as long as both the landlord and the tenant desire. It is terminable by either party at any time. However, many modern statutes have eroded this common law freedom by imposing mandatory notice requirements, often 30 days. This tenancy is characterized by its mutual, voluntary consent. In stark contrast is the tenancy at sufferance. This arises when a tenant rightfully in possession wrongfully holds over after the lease term expires, the holdover tenant. This situation is involuntary for the landlord. The landlord has two distinct options. First, the landlord can treat the holdover tenant as a trespasser and initiate eviction proceedings. Second, the landlord can choose to consent to the tenant remaining, which typically converts the tenancy into a new periodic tenancy, usually month to month. Understanding these two distinct scenarios completes our survey of the 4 leasehold estates. Now that we have thoroughly examined the 4 types of leasehold estates, we transition to the fundamental duties implied in every lease agreement. The first and most universal of these is the covenant of quiet enjoyment. This covenant is implied in all leases, whether they are residential or commercial. It guarantees the tenant the right to the undisturbed possession and use of the leased premises, free from substantial interference by the landlord or those acting under the landlord's authority. A breach of this covenant can manifest in 3 primary ways. First, there is actual eviction, where the landlord physically excludes the tenant, either entirely or partially, from the property. Second, we have partial eviction, which is a physical exclusion from only a portion of the premises. The most complex scenario, however, is constructive eviction. For a constructive eviction to occur, 3 elements must be met. First, there must be a substantial interference with the tenant's use and enjoyment. Second, the tenant must give the landlord notice of the defect. And third, the tenant must actually vacate the premises within a reasonable time. If these conditions are met, the law treats the situation as if the landlord physically evicted the tenant. While the covenant of quiet enjoyment applies universally, our next implied duty, the implied warranty of habitability, or IWH, has a much narrower scope. This warranty applies almost exclusively to residential leases. It is a modern development, fundamentally shifting away from the old common law rule where the tenant was responsible for making necessary repairs, often summarized by the doctrine of caveat lessee, or tenant beware. The IWH mandates that the landlord warrants the premises are fit for basic human habitation throughout the tenancy. This is not merely about structural integrity. It requires the dwelling to meet minimum standards of health and safety. The benchmark for determining habitability is typically found in local or state housing codes. Crucially, because this warranty protects fundamental human needs, courts overwhelmingly hold that a residential tenant cannot waive the implied warranty of habitability, even if they sign a lease. Attempting to do so, this warranty ensures a baseline quality of life for the renter. When either the covenant of quiet enjoyment or the implied warranty of habitability is breached, the tenant gains specific remedies, though the application differs based on the duty violated. If a breach of quiet enjoyment results in a constructive eviction, meaning the interference was substantial, the tenant notified the landlord, and the tenant vacated, the tenant may terminate the lease and seek rent abatement for any rent paid covering the period of substantial interference. For breaches of the implied warranty of habitability, tenants have several powerful options. First, they can terminate the lease and vacate, similar to constructive eviction. Second, they may pursue the repair and deduct remedy, where the tenant pays for necessary repairs and deducts the cost from future rent, provided the repair cost is reasonable. Third, and most commonly tested, is rent withholding. Here, the tenant stops paying rent until the condition is fixed. However, be extremely cautious. Many jurisdictions require the tenant to place the withheld rent into a separate escrow account to preserve this remedy. Failure to escrow can result in eviction for non-payment. Always check local statutes regarding the precise procedure for withholding rent, as rules vary significantly by state. To conclude, let us synthesize the most critical distinctions for the uniform bar examination. First, briefly recap the 4 leasehold estates: tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance, remembering their specific termination rules. Next, focus intently on the scope difference between the 2 implied duties. The covenant of quiet enjoyment is universal. It is implied in every lease. covering both residential and commercial agreements, protecting the right to possession. Conversely, the implied warranty of habitability is narrowly applied, generally limited only to residential leases, and typically cannot be contracted away. Memorizing this scope distinction is vital. Our final visual checklist contrasts these key elements side by side for efficient final review.